Hello, everyone. Thank you so much for your interest in the Unfortunate 500 project, which is about lifers, over 500 lifers, who have a sentence that is not clarified as to whether or not they are eligible for a hearing for release or parole. This does not guarantee release, it only guarantees the ability to go before a board, and that board decide whether or not, based on based on their conduct in prison, whether or not they're eligible for release. This story begins with the incarcerated people and the questions that they started to have for their sentence. And my hope is that I can give you this information and you can, understand it, relay it, and hopefully just help with this legal issue. We are not talking about cases, specific cases. We are simply talking about a legal error that has not been addressed um, fully. And so we're hoping that this can get addressed through legislation, where they can simply re acknowledge that the lifers who were sentenced post 1994 do, in fact, have a hearing coming. And we hope that they will come to that conclusion based on the information we provide here. Um, there is a timeline that we have been able to identify, that tells a story of how the confusion of these sentences came about. And so the timeline starts with truth in sentencing. It also includes computer software developments. It also includes the juvenile lifers in Arizona, and the landmark case of Miller versus Alabama, or USV Graham. And this also came about through articles written by the Arizona Republic, who also questioned the sentences of the 25 to life people. We also have courts or cases who also began to question their sentences. And so there are events, different events that took place that allow us today to give a more clearer perspective about what happened to the unfortunate 500 people who are questioning their sentence. What we have found, according to our timeline, of which we are not providing dates, this is just a very broad overview of what happened. I will provide links for research that I have done, and so that you could do your own cross referencing and hopefully help build the conversation around the unfortunate 500. We do begin this story with truth in sentencing, or the crime bill that passed in Arizona in 1994. That bill came as a part of a grant that was proposed to all 50 states by the United States government, to implement harsher sentencing in their states. Harsher sentencing as like 85%, like mandatory minimums, like abolishment of parole. And so Arizona decided to go ahead and move forward with this uh, crime bill, and it was implemented in 1994. So the first cases um, to be sentenced set the tone and set the tone for how everyone is going to be sentenced afterward. Now we have to talk about legislation, and when legislation changed, parole was removed out of the legal books, including the sentencing guidelines that have to do with the people serving life sentences. And so the word parole was removed from the legal books, and but release was put in replace for different types of release eligibility under the Truth in Sentencing Crime Bill. I won't go into detail about all of that, but just know that that parole as a word was removed from the legal books, and the term was still used as a release term within the people that were most impacted, that being the 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 people sentenced, the defendants, the lawyers, judges, prosecutors, Department of Correction, release people, counselors. Everyone was using the term parole and still uses it as if it still existed. So no one had any reason to really question whether or not um, a parole hearing would be available, or a release hearing or a hearing would be available for anyone sentenced to 25 to life in Arizona. So for 2 decades approximately, people in Arizona were constantly being given a sentence of 25 to life. Most cases will have another option of death or natural life, or 25 to life with the eligibility of parole. And so the majority of people were receiving, the 500 were receiving 25 to life with the eligibility of a hearing at some point. It was stating that in their paperwork, and no one had any reason to question it. In fact, no one did. Until, um, well, actually, I take that back. A former uh, parole board member who was part of the transition from um, truth in sentencing, he did wonder if whether or not the abolishment of parole was going to impact people sentenced to 25 to life. He appealed it to the Arizona courts, of which no remedy or guidelines were provided. So then, as people started being sentenced to the 25 to life sentence, they were going into prison, and they would get what we call time comps, or paper that gives you your release dates, or dates that you have coming to you. The lifers were receiving a time comp, and they had a date that they would be eligible for a hearing, and then the date that they would be eligible for release should they be granted release at the parole board hearing. They also, when they would go into lifers, they could go to a counselor and ask them to check in Ames for their dates. Any information that is connected to their incarceration would be located in the adult inmate management system called Ames. And so the Ames software over time stopped showing the actual parole hearing date and a release date, and instead was showing zeros, or it was showing the word life on the computer screen. If a loved one on the outside wanted to look at the Department of Corrections screen and look at their date, prior to software upgrades, the system was showing a release date or a hearing date, and then a potential release date. And so family members, when they were looking on the computer, started noticing that the dates were also missing from their view. So questions started coming up throughout the years as to why lifers had a date, and then all of a sudden they no longer have a date. With those situations arising, litigations or cases, people were looking to file motions or claims to find out what is going on with their sentence. Are they going to be release eligible or not? Some of these claims came about as a result of plea hearings, plea bargains, and people taking pleas for a 25 to life sentence with the expectation that they would have a hearing at some point and be release eligible. And that When the sentences started changing on the computers, people started questioning, well, am I going to have a parole board date? So litigations started happening, motions started being filed. And so courts were starting to discuss this issue. Now that questions were arising about sentences for life to life, there also were issues that were brought up on a Supreme Court level, the United States Supreme Court level. And what that means is that a decision was made in the Graham Miller, or Miller versus Alabama, USV Graham. The issue in this case, landmark case, was about juveniles and whether it was cruel and unusual punishment to sentence a youth, any youth, to a natural life sentence or a sentence without parole eligibility. And when that issue was, or when the case came down, the question then became, are Arizona youth also part of this category of youth offenders serving a um, a essentially natural life sentence where they cannot be considered for their maturity, um, and they should be the United States Supreme Court verbiage was they should be afforded a meaningful opportunity of release that shows maturity and growth over time. And so the issue then came to Arizona, and youth offenders were then inquiring through advocacy groups, lawyers, attorneys, about whether or not they were parole eligible. No one could provide a solid answer until litigations continued for one specific case. And then the Arizona legislator went ahead and decided to pass a law stating that all youth, to remedy the issue about youth offenders with life sentences in Arizona, in 2014, a law was passed that allowed for youth offenders to go to a hearing um, for consideration for release. When that conversation and decision came down, the conversation about parole eligibility intensified, and it was more intensified and by way of articles produced by the Arizona Republic that reached out to numerous offenders with life sentences and asked if they knew whether or not they were parole eligible. And that kickstarted the conversation about an illusory sentence or a sentence that isn't so, or the de facto natural life sentence. And so from that point, more litigation started to happen, more questions started happening, and audits of time comps were happening. Any paperwork that stated sentencing paperwork that stated parole was eligible for said defendants, they were allowed to go to a parole board hearing. And so these are the biggest factors that are connected to the situation with the lifers and life without parole and parole or not. Um, what we are finding now is that the computer system glitch essentially allowed for reinterpretation of what the 25 to life sentence is and what it is not. And we believe, again, that when truth in sentencing was passed, it did not impact people sentenced to 25 to life because that is the word that is the harshest sentence that any offender could get under a specific sentencing structure for a crime or for a specific crime. Usually you have three options: death, natural life, or 25 to life. The sentencing structure for offenders in this sentencing bracket could not get any worse. Therefore, the truth in sentencing would not have any impact on offenders under this sentencing guideline. We believe that the Department of Corrections, the court, Arizona courts, all intended for a release process to take place. We believe that when upgrades to the system um, missed the calculation of lifers and failed to code in that there would be a certification process that already exists, that the process already existed, that the coding for that should have never been affected, but it was. And that coding essentially took out the lifers and the sentencing bracket that allowed them to be released or to go to a hearing, to potentially be released. Um, so the remedy is essentially that our courts and that legislation and that the Department of Corrections all acknowledge that yes, the intention was for um, all people sentenced under these guidelines to receive a hearing at some point for consideration for release after 25 for serving 20 after serving 25 years. um, so yeah, we believe it was a software error. We believe that the system and the new admin is somewhat behind on what the old sentencing infrastructure within the system looked like, and so we're hoping, one, that we could get this fixed, get everyone's sentence in straight and in order. We also are hoping to support anyone who has a parole board hearing, that we can help to provide you with a meaningful packet to best display, how those incarcerated succeeded while incarcerated, and help them to just present their case. People on the inside who have this type of a sentence have had limited resources and access to programming, because of policies that prevented them from getting the full programming and education that was offered. That is not to say that people who have been serving 25 years do not have the ability um, to self help, and I know that they have. And so we just want to be sure that we are too supporting their opportunity for meaningful release or meaningful hearing. Um, if you have any questions or you want further information, again, please feel free to reach out to me. And also, any research information links will be provided for you. In order for us to continue to support people on the inside, we have shirts that you can get to just further support them. And so, hopefully you will do your part in any way, shape, or form. But we do appreciate you at least acknowledging the information, and hope for a solid remedy. Thank you.